What do you say? We get started. Please, Katie and anyone, let me know if I cut out or you missed something or you couldn't hear me. I have been having some internet/Zoom issues, but you can write in the chat or in the Q&A. And also, we have a lot of time for this session, so please feel free to interrupt with a question. Thanks, Jeff. At any time in the chat or, out loud. Wait, can you talk? You can't talk in the webinar. So yeah, in the chat. And we're happy to take questions throughout the conversation. These things can be really confusing. So I'm going to just put the slides up one more time before I start going. So welcome everybody to today's Author Rights Workshop, What to Look For in Publication Contracts. My name is Katharine Dunn. I'm a scholarly communications librarian here at MIT. I'm co-presenting this with my colleague, Katie Zimmerman, who is the Director of Copyright Strategy in the libraries. And have I missed anything, Katie? I think that's all we wanted to say at the beginning. Please interrupt us with questions, chat or Q&A, and we'll get started. Oops, sorry, this is not, okay. So you've done your research, you've gotten your results, you've written them up, and now you're gonna go publish your journal article, your conference paper, or whatever. But usually before you do so, you need to sign what is called a bunch of different things. It could be called a publishing contract, author agreement, license to publish, copyright transfer agreement. Essentially, so when you write something, when you create something, you are the copyright holder of that thing, of the article in question. You own the exclusive rights to reproduce and adapt, to publish, perform, display. These are your rights that you hold under copyright. And in order for someone else to use the work, in order for a publisher, for example, to do what we want them to do, which is to disseminate it under their brand, to push it out there to the world, they need the rights from you to be able to do that. And that's what a copyright author agreement publishing contract does. The reason that it's really important, or a reason it's really important for you to pay attention to your publishing contract, is that it is a transaction that governs your future relationship to and rights in your work. And copyright lasts a really long time. It lasts life of the author plus 70 years. And so that's a long time. And you want to know, and this is your work and you're signing your rights over to it. So it's really important to read your contract early, look at publisher websites to see, even before you have a contract, to see what kinds of rights the publisher gives you back once they take your copyright away. And you may even want to use that as a basis to think about who you want to publish with before you go ahead and do that. So one thing we're going to talk about a bunch today is what you want to do with your published work. And this is a really important question to ask yourself before you sign an agreement with a publisher. Are you a graduate student who is working on your thesis and you're getting a paper published that you hope to adapt or use wholesale in your thesis? That's really important to know. Do you want to post it on your personal website or in a repository like DSpace or like Archive? You might think those are websites that are all openly available to the world. What's the difference? Well, publishers do see a difference between these different kinds of sites and repositories, and they have different rules for what you're allowed to do with them and what versions of your paper you're allowed to post and where. So it's really useful to think about the kinds of things that you might want to do with your work before you go in and sign a contract and sign your rights away in it. Sorry. Some common things to look for in an author agreement. So this is really small. I'm going to zoom into that in a second, but this is sample agreement. And by the way, all the agreements that we are showing you today are all publicly available online. There are links on all of the pages to the agreements themselves. Publishers do often put a sort of generic agreement online. So in this Elsevier agreement, this is a really common, probably the most common type of agreement is a copyright transfer. That is where, as I just said, you are signing over that bundle of rights under copyright over to the publisher so that they can go ahead and distribute it and copy it. So what that says more specifically is, I hereby assign the copyright. This assignment of rights means that I have granted to the copyright owner, and they are now calling themselves the copyright owner, Elsevier, the exclusive right to publish and reproduce the article in any form, in all languages throughout the world for the full term of copyright. And again, that's a really long time. It's life of the author plus 70 in the US. So that's one type, that probably the most common type of author agreement, a publishing agreement. Another type of agreement is a copyright license agreement. This one is from, there are several publishers that do these kinds of agreements. This one is the Association for Computing Machinery. Wait, is that what they're called? Anyway, ACM. And they, so this one says it's a grant of rights to them. You are hereby granting ACM an exclusive worldwide, et cetera, license to publish, reproduce, and distribute. And so in practice, this is, you know, in theory, and I mean, you are holding on to copyright in this kind of agreement. ACM, in fact, will have your name next to the little copyright symbol on your journal article, but you are also signing all of those rights under copyright over to ACM in an exclusive license. And exclusive is a really important word because it means that no one other than ACM can make use of those rights under copyright, and that includes you. So as with the copyright transfer agreement, you're going to want to look at the rest of the contract as well as what's on publisher websites to see the kinds of rights that the publisher gives back to you as an author, so that you can do some of those things I talked about in terms of reusing your work and allowing others to use your work as well. And so with this license, it also says, it may not say it here, but they often say for the duration of copyright again, so that they're taking an exclusive license to those rights under copyright for the duration of copyright. Sorry, my Zoom is going very slowly right now. And so as I just said, so at the top of an author contract, a copyright agreement is usually the transfer, and then lower down you'll see the publisher, more or less detail from the publisher in terms of what you are allowed to do once you've transferred your rights over to the publisher. This is from the ACM agreement from the previous page. And they go into quite a bit of detail. They tell you, that you can do a presentation with the work. You can post where you can post different versions of the work, the accepted version, which is usually the peer-reviewed version, but not in the publisher's layout, where you can post that and when. Is there an embargo on any of the versions? Are you ever allowed to post the final publisher version? Generally not, that kind of thing. So it's going through a list of all these things you can do. Sometimes they'll talk about whether you can use it in a thesis, whether you can, make translations and so on. So that's really important to look at. It is very often the case that publishers include more information on their web pages about your rights as an author and what you get to hold on to than they include in the contract itself, which is really unfortunate because you are signing the contract and not the web page. Sometimes they'll even say, sign this contract and then go to the web page and find out more information, which is not ideal. So it's useful also to go to their websites to see the kinds of things they allow you to do. And they do change their policies also somewhat regularly. So it's useful to make sure they're up to date. Oh boy, this is really slow. Hold on, I'm gonna have to, let me just start it again, the slideshow again. All right, now we're on to Katie.
All right, thank you, Catherine. So getting into a little bit more of the meat of the contract, a couple of important things to look for. And one of them is the rights reversion. So Catherine talked us through the ways that rights transfers might look. They might be a license, they might be a copyright transfer. But one thing that you want to make sure is in there is if something goes wrong, if they don't end up publishing your work, that you're not stuck. So you want to make sure that there's a rights reversion such that if later on in the editorial, an editorial decision is made and they no longer want to publish this, that you can take it somewhere else. So that's a pretty important provision to find. And go ahead, next slide. Another one is third-party materials. So this is one that you want to think about sooner rather than later. You want to know what your publisher's expectations are, what work you're going to have to do. This is something that sometimes trips people up at the last minute because it can be quite a lot of work that they didn't necessarily realize was coming. So what this is about is basically anything in the contract that anything in the work that wasn't created by you. So this could be a figure that you're using that was created, that you got from a previous paper. This could be a section of a literary work that you're analyzing. But anything that isn't created by you has a copyright that belongs to somebody else, potentially, and you need permission for that content to use that content. And then the question that this clause is going to address is who has to go out and get that permission? Is that you? Is that the publisher? What is that needed in all cases? Because permission isn't required for all things. Your inclusion of something, if you're building off of it in commentary or criticism, could very well be a fair use. Does your publisher accept a fair use argument, or are they going to kind of take the more conservative approach and say that you need to get permission anyway? So the specific language of this can matter. There are a couple of examples here, and some contracts will say you have to get permission in every case. Sometimes you will even say they will even require that you need to provide documentation of permission to the publishers, so you need to submit the letter that you received from everywhere that you got materials from saying, yes, this is okay. That's kind of the extreme version. Some publishers will be open to not getting permission if it's either something that isn't covered by copyright or something that's covered by fair use. So it could be older materials that are in the public domain, or something where your use is a fair use. We also have IAP sessions on fair use and the public domain as a shameless self-promotion. The public domain one is tomorrow. The fair use one, you'll have to wait for the recording to come out. It was last week. But so the specific wording, what you're going to be looking for is something that says all necessary permissions. That kind of leaves some room that you don't need permission. There are some times when permission isn't going to be necessary, as opposed to you're going to get permission for everything. So that can be that's a relatively subtle linguistic point, depending on the sorts of materials that are in your contract. This is something to perhaps discuss with the editor if it's not entirely clear from the contract itself. So next slide. Okay, so warranties and indemnities, and we're getting into some of the things that can be a little bit daunting as legalese in contracts. But so warranties are basically, in this context, are where you're kind of stating for the purposes of this contract that this is true. So you as the author warrant that these things are true. If they're not true, then you're going to be in breach of this contract. And if you're signing this contract, that means you don't want to sign off on these if they aren't true. So you want to go through everything that you're warranting and make sure that it's accurate. Most of these things are going to be pretty straightforward and easy. Assuming you're on the up and up and everything is good, you're going to be able to very easily warrant that this work is original, that it's not intentionally misleading or inaccurate, that you haven't previously published this elsewhere. Those are things that are probably going to be pretty straightforward. Depending on your work and the situation of it, there are things that you might need to discuss further. Usually something hasn't been previously published, but maybe one chapter of this book was heavily based on something that also appeared in your master's thesis, for example. That might be something that where you would want to discuss the prior publication policy with the publisher to make sure that you can accurately warrant things according to this contract. Similarly, things like nothing in the submitted work is obscene, defamatory, libelous, or otherwise unlawful. That should be pretty easy to promise. But on the other hand, it's not defamatory according to you. Maybe you're writing a book about a historical figure who is still living and is very litigious. That might prompt you to consider more carefully the implications of this particular clause and perhaps have that conversation with your publisher about it and about where the that particular risk is going to lie. Similarly, this example is asking you to warrant that you're not infringing any duty of confidentiality. If you've had access to confidential sources, you've had access to proprietary sources, you want to make sure that you're not in violation of any of those contracts, because those can in turn get you in trouble in this contract. So it goes on. You want to make sure that this is all accurate, and then at the end here we have an indemnity that kind of wraps all of this together. So it says you're indemnifying the publisher for any claims, costs, expenses, including attorney's fees, arising out of breach of any of these warranties. So basically you're saying all of these things are true about the work. You're representing that it's an original work, for example. And if that turns out to not be true, if it turns out that this is blatant copyright infringement and you're getting sued, then the indemnity is a contractual shifting of liability. It says that you're agreeing ahead of time that that's going to be on you instead of on the publisher. Now, sometimes that's entirely appropriate. You are in a much better position than the publisher to know whether this work is original, whether this work is defamatory, whether you've gotten third-party permissions. So that can make sense that you're responsible for that. You're going to continue to be responsible for that if it goes wrong. What you want to avoid, though, is a very broad indemnity. So next slide. So this is an example of this. This is actually from a copyright colleague of mine. And so this indemnity clause says the author shall indemnify and hold the publisher harmless from any claim, et cetera, instituted by reason of publication or sale of the work. So that's a pretty broad set of things included there. That could be all the things that we just talked about. That could be the work is defamatory. That's you're liable for that. But that could also be things that the author really has no control over. So this could be a book contract. Maybe the publisher, elsewhere in the contract, it specifies that the publisher gets to choose the cover art, and the cover art turns out to be infringing. The author didn't choose that. Author didn't really have anything to do with that decision. But according to this clause, they're agreeing to take on liability for that. That could be something even more even more divorced from the author's decisions. That could be the publisher is failing to pay their import taxes. If that's arising out of sale of this work, then in theory, at least, the author is saying that they're still going to be liable for that. So this is really kind of overly broad. This is something that you don't want to do. In this case, this story has a happy ending. This colleague spoke publicly about this, talked about what was wrong with it, and actually why they had agreed to it anyway. But they were very unhappy with it, and the public pressure arising from that got the publisher to go back and come back to them with better language. So that's a success story. You want to be that sort of author. You want to assert your rights and not sign things that are very bad for you.
Katie, can I ask you a question about indemnity?
Yeah.
I'm curious if you know if sort of how often this ever even comes up as something that is you know, a problem. Do you have any sense of that? Like, how often it is? Yeah, sorry, go ahead.
That is a good question. So I think it probably does not come up very often in academic writing. It could come up. It depends on how controversial your work is, and it depends on, frequently it's going to depend on how much money is at stake. So, you know, I don't think it is a secret that most academic authors are not publishing for those big royalty checks. So that can make you feel a little bit better about it. The indemnity clause isn't really going to kick in unless there's already a lawsuit involved, in which case things have probably already gone pretty wrong. But it does happen sometimes.
Okay, great. That's helpful. Thanks.
All right, let's go to the next slide. And so then you also just want to, so those are some common things. These are a couple of examples of more common things, but you also just want to make sure that you've read everything in your contract. Look out for anything odd, look out for anything that you don't understand. Don't be afraid to ask about anything you don't understand. You can ask the publisher, you can ask the editor. This is also a service that Katharine and I provide. Our contact information is at the end of the presentation. And this is a service that we offer. We will go through a contract with you and help you determine what is in it, what things you should maybe look at. But so what else do you see? Some examples, particularly in book contracts, there's going to be a lot more detail. There might be specifics around turnaround times, delivery, how long are you going to have to review proofs, how long are you going to have to edit this? You want to make sure that all of that is actually reasonable. Can you copy edit the entire book in 3 days? That might be reasonable, might not be. So you want to review all of that. And then my other example that I have here is the governing law and jurisdiction. And this is something that you may be able to negotiate or might not, but it's something that you want to know about. The publisher in this case is the one providing you this contract. They're going to provide you a contract that meets their needs before it meets yours. And if they're located in a different place than you are, they're generally going to want the contract to be interpreted according to the law that they're familiar with instead of the law that you're familiar with. So in this case, if I'm an author in the United States, in this example, I'm agreeing to the law of England. Law of England is notably much less favorable to defendants on defamation. So that might be something that I'm worried about, depending on the topic of the book. And also subject to exclusive jurisdiction in the English courts, which, you know, you hope you're never going to get into a dispute where you're in court about this, but if you are in court about this, you're going to have to go to England to do it. And that in itself can be a big deterrent from asserting rights that you might otherwise have. So that's something that you at least want to be aware of, even if it's something that you're willing to accept because it's unlikely to actually occur. All right, let's go to the next slide, and I'm just going to pause there for a second and see if we have any questions at this point.
We had a question, but you answered it.
Excellent.
Thank you for that. About it was if people didn't see the question, I don't know who can see what, but it was for faculty and students who are presented with a copyright contract, do they need their own attorney to review them, or does MIT offer to review them? And Katie, as Katie said, we provide that service in the libraries for sure. You certainly do not, in my opinion, need a lawyer to look at your journal author agreement in particular. They're pretty standard. We've seen most of them, or many of them. We also look at book contracts, and they can be less standard and also can be more open to negotiation, which we can talk about a little bit later. And we also will look at those.
Yeah, and I will add a little bit of a gloss on that. We can't provide you with legal advice.
Oh yeah, right.
But we're not acting as your lawyer in that review. We can't negotiate it for you. We can't do that sort of thing. But we are familiar with this, and what we can do is we can go through it so that you can make your own informed decision about it.
Good answer, Katie. Yes.
Yes. Okay, so next we're going to do, to kind of make this a little bit more concrete than the kind of theoretical that we've just looked at. Let's actually look at a contract. So Katharine just put this link in the chat. If you can go take a look at that, that is an actual contract. It happens to be from the American Chemical Society. I do want to say that we didn't choose that contract because it's particularly bad or anything. We're not calling them out in particular. Actually, I appreciate that they make their contract available before you've submitted an article to them. So that's already a good place to start with, that they are letting you see this, and they're a fairly standard sort of contract example for a journal article. So we have that contract. I will stop talking in a second and give you a chance to look at it. And as you look at it, we're going to try and answer some questions about it that you might have as an author. So I will go ahead and launch this first question as a Zoom poll. And so the first question you just want to think about as you look at this contract is who owns the copyright after in this article after the contract is signed. Just answer the Zoom poll once you feel like you know the answer.
Katie, do you want me to pull the contract up on the screen?
Yeah, let's go ahead and share screen with the contract.
Okay, whoops. Do you see that screen?
Mm-hmm.
Yeah. Okay. And I will zoom in a bit. Katie, I don't see the poll. Do you still see the poll? Just wondering. Okay.
One person has answered the poll.
Okay, great. If anyone needs a hint about where to look, you can ask us.
I'll go ahead and show the results on this one. Yay, we're all right.
Yay!
Everyone who answered the poll got this one right. The place to look for this, yeah, Catherine has just highlighted it. It's front and center, and this is a copyright transfer. So this is the author transferring their copyright interest in the article. This publisher, like most publishers, actually has several variants of author forms. Sometimes there are different forms for different ones. This particular variant is the copyright transfer variant. So the next question is, let's say you are an academic author, you work for an academic department, and your department has a website that showcases the research done in your department, and you want to add this paper that you're about to publish. You want to be able to put it up on your departmental website. If you sign this contract, can you do that? I'll give people a few minutes. I can't tell is definitely a viable option.
I just noticed something I haven't seen before. I was in answering Jeff's question, I talked about how standard these agreements are, but this one being American Chemical Society talks about chemicals that you use in your, or hazards inherent in the chemicals and how they have to be disclosed to the editor, which is pretty great.
Yeah, I think that was actually in the list of warranties in that I kind of skipped over, but yeah, that is something that you see sometimes.
Oh, that's great. That's great.
Medical journals, sometimes you get ethics questions around, like you're asked to agree in the contract that you've followed institutional IRB for human subjects research, that kind of thing.
Yeah, sounds fair. Sounds good.
Yep. All right, some answers are starting to come in.
All right.
All right. So I'll just go ahead and show this. We have an I can't tell and a no. And this one is, so this is actually kind of an interesting example. It's also a relatively typical example. Can you scroll up to the near the rights section again? So what the publisher is doing here is they're kind of, exactly. So they are, so you're transferring your copyright to this publisher, and then they're giving you some rights back that they think you as an author are going to want. So that's how they're kind of handling the disposition of these rights. They're saying, we get all these rights, but then we're going to give you some things back. But then the things that they're giving back aren't actually in the contract itself. The things that they're giving back are at this link. So actually, Catherine, can we go ahead and go to that link?
For sure. Yes, this is kind of annoying.
Yes.
Because as you can see, they change it, you know, so that's unfair. That's unfair, I think.
Exactly. So this is a relatively subtle point that you might not realize if you don't read contracts all day like I do, which is that if these things are in the contract itself, you have ink on that piece of paper. Those things are the things that they are. They're not going to change. What's happening here, though, is you're saying, I agree to follow whatever policies are at this link, and they could change those policies on you. So they could change those policies on you. The other thing that happens is that's fine right now, but 5 years from now, when you're working on a new project and you want to reuse this content in something else, that link is, there's a very good chance that link is broken. The terms have changed. You don't even know what the terms were at the point when you signed. So that can be a problem. That can be something that that you want to anticipate. I always recommend, if you have a contract that does that, save a static copy of this website as well. Anything that's linked out in your contract, print out a copy of it at the time when you signed, so that you know this was the policy, this was what I could do at the time when I signed.
Yeah, that's very smart.
Okay, so let's try and answer. So now from this page, let's try and answer the question, would you be able to put your article on a departmental website?
So this is about, so the question was about putting it on a website, right?
Yes.
So this is theses or collections. That's not it. Figures and future works. Reuse in teaching or training. No. Presentation at conferences. Sharing with colleagues. Posting to websites. Okay.
Yeah, so the answer here is kind of a yes and no, and it's a pretty common yes and no. So you can post certain versions of the website of the article to a website, and they're going to have specific rules about what versions you can post. They might have a required period of time that you have to wait, called an embargo, before you're allowed to post. And they might have certain statements that they want you to attach with it. So this is kind of a qualified yes, actually, but only after you read through your contract, figure out that actually it's in this website, and then decipher this website.
Right, and you have to know often how they define, so they will have these terms like submitted work with capitals, and different journals and publishers define versions and works in different ways. So that can be confusing as well. All right, back to the contract.
Sure. And I think I'm going to skip some of the intermediate polls, because we have, you can see in the slides all of the questions that we identified. Most of the answers to those are still on that posting policies page, and have some variant of the qualified yes. So questions you might have: would you be able to send a copy to a friend? You have a colleague at an institution, they contact you over Twitter, they say, I would really like to read your latest article, but my school doesn't subscribe to this journal. Could you send me a copy? If you went to your contract to figure out whether you could or not, figuring out the answer would look a lot like figuring out the answer to the last one. I believe it's also a qualified yes. Can you use figures in conference presentations or in other article? We also saw that on that page. Can you use the article in your thesis? That's a very common question we get. There are a lot of disciplines where it's very common to use journal articles in theses. Articles become parts of theses. Parts of theses become articles. Is very normal in the field, but it has copyright implications and it has contract implications in the contract that you sign. You want to, if that is the position you're in, you want to make sure that you're not creating problems for getting your degree by publishing. That is the opposite of what you want to be doing. So that's an important part of your contract to look for if you are in the process of or anticipate doing a thesis related to that work. Let's answer the question, would you need to obtain permission for third-party materials? So I will pull up that poll. And by this poll, I mean permission for all third-party materials. Would you need to document permission if you felt like your use was a fair use, if you felt like the material was in the public domain, what does that look like in this contract? Okay. Few people have weighed in, so I'll go ahead and end the poll. We have one very honest person who can't tell.
Thank you for sharing.
And I commend that strongly. Even if it's in there, sometimes it can be buried pretty heavily.
Yeah.
And if you can't find it, it is perfectly okay to ask. These are things that you should know and should understand about contracts that you're signing. So it looks like one person found it, and it looks like Katharine found it. I believe it is in 2B.
It did take me a minute though. I had to scroll down and look.
I was actually frantically trying to re-find it on my screen too. And so what does it say? So it says that the authors have reviewed this agreement and agree with all of these things. One of these things is any third-party quotations or figures have been appropriately noted in the article and fully identified in the references. And in the case of illustrations in particular, the authors have obtained full permission, distribution rights in all media and all territories from the illustrator or their agent for republication in this article. Same permissions process would be required for any reuse of any substantial third-party text elements beyond 50 words. So this is in fact a pretty conservative permission policy. They want permission for everything except everything, including quotes beyond 50 words, and they want you to get that.
To you, does this make clear, Katie, that fair use would not be accepted, or would you still recommend people could try a fair use argument?
If you had, so I will always recommend people try a fair use argument if they have a good reason to. And I can't tell if I'm frozen or you're.
I'm frozen.
Okay. So my guess here would be, this is a chemistry journal. Most of the third-party figures are going to be scientific figures, which are relatively easy to get permission for. And so they're saying, just go out and do that. That may in fact be the path of least resistance in this case. Where it's more helpful and sometimes necessary actually to rely on fair use is going to be things where the materials you're using, where it's not easy to get permission. They might be things that where you don't know who created them, or you don't know, you know who created them, but that person died 50 years ago and you don't know who their heirs are, and copyright lasts a really long time, so they're still under copyright. It could be things that it could be things where you know the estate and the estate wants to charge large amounts of money for it. So this can be a problem in like art history and things like that, where the license fees for this permission can be very, very steep, and that's unnecessary if it's a fair use. So that can be that would be a situation where you might want to do that. Things that are in the public domain and very old, and you don't need permission for those. You shouldn't have to go get permission for those. Those are free for anybody to use. So if you're in one of those situations, then even when it's language like this, I would argue that you should try and make the pitch to your publisher. Because the alternative, if they really are going to require permission for some of those materials, would be that you just can't use the materials because you can't get permission because there's no one to get permission from. So you can always make that pitch. I would read this clause as saying they're not very open to that. They really seem to want permission for everything in this one.
Right. Just two small things on that. Thank you. That was very helpful. One is permission doesn't always mean, as Katie said, with public domain, that you have to actually ask someone for it. So for example, on our front page of our, whoops, I just moved that, of our talk, it says our talk is under a Creative Commons license, and that is your permission. That tells you what you are allowed to do with this talk as a reader, user of it. The CC license, if you go to the URL there, it will explain what attribution non-commercial means. That is a permission for you. The other one is just a pitch for if you are at MIT and you are, say, a grad student working on your thesis or working on a paper, a researcher working on a paper, and you want to use other people's figures or bits of text. We have agreements in the libraries with various publishers that allow you as authors to not have to go and ask for that permission or to worry about whether your use is a fair use. And we have information about that on our website. And so if you have questions about that, let us know. But those are really great agreements, and we have them with lots of publishers.
Yeah, so just to play around with this a little bit more, I don't have a poll question for this because it's kind of free answer, but if you want to put your answer in the chat and tell us what law and jurisdiction apply to this contract. Let's see if we can find that information. It is buried. Yes, so Jeff has found it. It is the laws of the District of Columbia. It is in 4B. So you're agreeing that DC law is going to apply, and I believe you're also agreeing that if you end up in a dispute with your publisher about this contract, you're going to have to go to court in DC.
Or over Zoom.
Or over Zoom. So hopefully it won't come to that. DC is better than the UK and Wales in terms of travel time for most folks, at least most folks at MIT. But that is something that you probably want to know before you sign the contract. And then I would just encourage you to look through the contract, make sure you understand everything in it. Anything unusual in it, Katharine noticed the warranties about hazardous chemical use. That could make perfect sense in your chemistry lab. If you're writing a history paper, that might give you a little bit of pause in that contract. But
Katie,
yeah.
we have a question from Jeff Wilson. Thanks for that, Jeff. Is jurisdiction typically a negotiable point?
Yeah, it's a really good question. So I would say probably not in a journal contract. It might be in a book contract. It's hard for things to be negotiable in a journal contract. That's a really hard thing about journal contracts is, you know, they know that publisher perish is a thing, and usually they know that they can wait you out. So it can be a hard thing to negotiate in a journal contract. A book contract, perhaps slightly less so. And a kind of an intermediate point that you can take is that I will sometimes do is to remove the jurisdiction clause, but allow the law to stand. So if the law is, I also, in one of the other hats that I wear is I negotiate contracts for the MIT libraries. So I negotiate contracts for content that we subscribe to. So I handle these clauses pretty frequently. And we know we find ourselves arguing with content providers over, are we applying Massachusetts law or New York law or DC law or something like that? And so we may know that we're okay with applying DC law. We still don't actually want to go to court in the District of Columbia if we have to. So we will leave the law in, but leave out the jurisdiction clause. And the effect of remaining silent, if you don't specify that, is that the court would then determine what law and what jurisdiction would apply. And they do that based on equity. And generally, it's going to be more equitable to for a corporation to send someone to court in Massachusetts than it is for you to travel to London for a court case. So in general, if you remain silent and you're the author, that's going to work out better in your favor in the unlikely event that it comes to it. But even if you can't negotiate it, then it is still something that you definitely want to know about your contract. All right, shall we hand it back to you, Katharine?
Oh, sure. Whoops. Okay, so we've been talking about obviously looking for things that you can do with your work that are in the that the publisher kind of the rights they give back to you, and what you can do after you've signed a contract. And we all know why that's so important. You want to build on your work. You want others to build on your work. Hopefully the publisher doesn't want to take those rights away from you, but sometimes they do, and that's too bad. So it's helpful to think about ways to hold on to your rights. And at MIT, we have a really great way to do so, and that's through what is called an open access policy. So since 2009, MIT faculty voted on creating an OA policy for faculty. So they've had one since 2009, that's 13 years. In 2017, after kind of much debate on how to do this, we being MIT expanded the OA policy to include anyone on campus, student, postdoc, grad student, undergrad, staff, and others, anyone who's currently affiliated with MIT can take advantage of an OA policy. The difference between these two, one is by default, faculty are covered by an open access policy, whether they know it or not, because of the way that they voted on it. And the rest of us sign what's called this opt-in license. And once you've signed it, then work that you create, that you complete once it's signed, is covered by an OA policy. So what is an OA policy? It's actually a legal tool. It's something that's written into copyright law. It is a license. We've talked a little bit at the beginning about, so there's a copyright transfer agreements and then license transfer agreements. And in the license transfer agreements, we looked at, those were a exclusive license transfer. So you are in those agreements with, say, ACM, you're transferring your rights under copyright to share and reuse and rework, remix your work exclusively over to ACM, and then you're reliant upon ACM to give you rights back. And an open access license is a different kind of license. It is a non-exclusive license. And so what it means is, and it's a bit complex, but in essence, you are signing, when you click on this as a non-faculty or as a faculty you've already kind of clicked on it just by being a faculty member. You have signed a non-exclusive license with MIT. MIT holds on to your rights under copyright for you to take advantage of if you want. You then go and complete a journal article, you go and sign a copyright agreement, transfer agreement with a publisher. And because of the way copyright law is written in the US, you are allowed to hold on to those rights under copyright, even if you've later signed them away to your publisher, because you had this prior existing non-exclusive license with MIT. So it is a legal tool, and it's very nifty, and it's why OA policies can exist. And ours at MIT has been extremely successful. So since 2009, we've put something like 55% of faculty published journal articles and conference papers into our institutional repository under the policy, many of those under the policy. And a couple other things I want to say about that. It is not a mandate. It is a tool to use if you want to use it. It is not, you are not signing your copyright over to MIT. As I said, you're signing a non-exclusive license. You can then go ahead and do what you would like with your paper, including signing over your copyright of it to a journal. You can publish wherever you want. This kind of open access has nothing to do with, it has no bearing on where you publish. The only way in which it matters where you publish is that there are some publishers that are not huge fans of open access policies and require authors to waive them or to opt out of them. And so, for example, Nature is one of those publishers where you, that's not a great example. Elsevier is a publisher that requires authors to opt out. And in fact, that is some language that you would find in your author contract with them. They say you cannot, any pre-existing agreements that you have made are no longer valid or something like that. And so that is specifically addressing things like open access policies. But most publishers don't require opting out. And so therefore it's just a really great tool that you can rely on as a member of the MIT community to hold on to those rights, to not only allow yourself to reuse your work in things like theses and talks and whatnot without worrying about what your author agreement says, but also allow others to do so. Because when we post things under the open access policy into DSpace, we do so under a Creative Commons license. And as we said, that's this permission that tells people up front what they can do with your work. So that is really exciting. And then Katie's going to talk about negotiation.
Yeah, so we've talked about this a little bit already, so I'm not going to say too much more. The OA policy that Katharine just described is, at its heart, it's really a tool to make it so that you don't have to negotiate for the ability to make your article open access, and that's because we know that negotiating is hard. It feels really awkward. It feels you're frequently, particularly if you're early in your career, it feels like you don't really have much power in that situation. And that may be true. It may be that this is the journal that you need to publish in, and negotiating is a really uncomfortable position to be in. So we do encourage you to use tools like the open access policy so that you don't have to be in that sort of position. But if you do want to negotiate, you can. And the thing to remember when negotiating a contract is you are the one producing the content here. You are the one, you have something that they want. And in order to get it, you have to come to mutually agreeable terms. So you can actually go through and with a red pen and red line a contract. That is something that we will help you with without giving you legal advice. But we will help you make informed decisions about what you would like to negotiate. And how to approach that sort of problem. And then, so the next slide, we're pretty much at the end here.
I just wanted to reiterate, sorry, Katie, one thing that you said earlier, which is that with journal articles, it's actually become increasingly hard to negotiate in that everything is done now on a platform online, and you can't even probably take the contract, download it, redline it, upload, attach it to an email anymore. You have to just do everything on this website. So journal, and also there's so many contracts going in and out of journals, editorial managers every day. They just are not really doing individual negotiations on journal contracts. But if you're adamant about it, I mean, you could try, right?
Absolutely. And kind of the bigger the project, generally the more negotiating power you have. So if book contracts are absolutely negotiable, you should always negotiate your book contract. And there could be intermediates between there. So if you have questions about it, I do encourage you to ask us and use some of the resources that we're going to talk about. Okay, so kind of the summary take-home points from the things we've talked about today. Read your contract. Read your contract, know what's in it. Even if you're not going to negotiate it, you still need to know what's in it. You need to know what obligations you're incurring, what obligations the publisher is taking on, and what the actual terms that this publication is going to happen under are. So read your contract. Don't be afraid to ask questions about your contract. Also, please keep a copy of your contract. You may feel like you completely understand where it is now. Copyright lasts a long time. 10 years from now, are you going to know what you can do with this work? Are your kids going to know what they can do with this work? It may seem it may seem far out at this point, but we do actually regularly work with people who are at the end of their long illustrious career, want to kind of collect everything into a collection, and are trying to track down these contracts. So put them in a file, keep them. You'll revisit them someday. When you're approaching a contract, start by thinking about what you want to do with your work. Think about what things are important to you specifically in this specific work, and then prioritize that for what you're going to approach. Some things to look for that we've talked about: copyright transfers and licenses and what the mechanics of that look like. Retaining rights to your work. Can you post it? Can you share it? Can you reuse it? What are your obligations around third-party materials and permissions? What are you warranting and what are you indemnifying people against? And then just anything else that seems odd or is important to you. You can use the OA policy to retain rights without negotiating your contract, and you can negotiate your contract if you would like to. Next slide. So we will share the link to these slides again, and then you will have all of these links. There are a lot of really good resources out there about this. This first one is a whole full-length book that will walk you through every single clause in a contract and help you out with that. There are model contracts that you can look at to see if your contract kind of matches what a standard one might look like. More information about the MIT Open Access Policy, and then links to additional resources. So there's a lot of great resources out there. There is also us. We have a website. It has useful things on it. You can always email us at scholarlypub@mit.edu. That's where you would email if you wanted us to look at a contract with you, or if you have a copyright or open access question, we also answer those. Or if you want to email either of us individually, our contact information is there. So we can take any more questions that folks have. We can have a little bit of a conversation.
Oh, we just got a question. Does anyone review publication contracts for MIT faculty? Not by standard. No, faculty on their own are in charge of their own publication contracts, or the corresponding author on their paper is the one who probably signs it. So we are here if anyone wants to look at them, but there's no other place on campus that I think offers that service, and nor do faculty or anyone have to show anyone their contract. Katie, did you want to add anything to that?
Yeah, so you are responsible for signing your own contracts at MIT as the faculty member. We are available to consult with if you would like us to look over a contract with you so that you know what's in it, and we can answer any questions you might have about it. But there is no kind of formal MIT review of publisher contracts. There may be an exception to that for Lincoln Labs, actually, now that I think about it.
There is an exception to that for Lincoln Labs. Okay. Lincoln Labs signs on behalf of authors.
Okay, so if you work for Lincoln, that is the answer. If you don't work for Lincoln, the previous answer applies.
Jeffrey says, great presentation exercise. Looking forward to public domain. Woohoo!
Yes, join us for talking about the public domain tomorrow.
Yes, so please be in touch anytime with questions. There are no dumb questions.